So we're recording now, Jan, so you know. Good afternoon, everyone. Welcome to the juvenile section and the CJA program with Janet Sherwood. This Bar Association thanks you all for joining us today, and I'm going to turn it over to your host for the meeting or the program, Adrienne, and she will introduce Janet.
So most of you have had the opportunity to meet Jan, but those of you that haven't, Jan Sherwood is the Deputy Director of Advokids and a co-founder of Advokids and has over 40 years of experience working in the child welfare law field. Her experience includes an in-house counsel job at the State Department of Social Services, serving as the Deputy Attorney General representing various state health, education, and welfare agencies, and more than 20 years in her own private law practice in which she represented parties in both the trial and appellate courts. She is a child welfare law specialist certified by the National Association of Counsel and accredited by the State Bar of California's Board of Legal Specialization and the ABA. Ms. Sherwood is also a consultant, trainer, expert witness, and frequent speaker on child welfare issues. So I just wanted to give you all a little bit of a rundown on the chat as well. I can see several of you have been able to access it. If you hover over your taskbar, that's where you should be able to see your mute, stop video, etc. Toward the center on my screen, next to participants, there's a chat button that you can press, and that will give you access to chat. And so the way that questions will be answered is that you should go ahead and put your question into the chat box, and then I will let Jan know that we have a question. And I think that is all that I have to tell you. I see from Amanda, we don't have a participants button because it is presentation style. Okay. Well, you found your chat button. So if anyone else has any questions, you can also, I guess, Anne, should they contact you, or should they can contact me if you'd like my cell phone number?
Questions about what?
About how to access chat.
Can't they just click on chat?
Yes, they can if they can access it.
Oh, you're saying they can't access it.
I'm not sure. I'm not sure. Well,
okay. There should be, there may be a thing on the screen that says more. Try under there.
Well, I think we should just go ahead and get started. And if anyone has any issues, they can either contact myself or Anne.
Okay, that's Anne, not Jan, because I can't tell you how to fix your Zoom and talk about what I'm supposed to be talking about at the same time. Okay, we ready to get started? Whether we are or we're not, we're getting started. Okay, we are talking today about representing the child in California dependency proceedings. The first sort of half of this is going to focus a lot on what the rules say your job is and what the rules of professional responsibility say that your job is. So first of all, every child in the welfare system, child welfare system, is entitled to appointed counsel. 317C says, unless the court determines that the child will not benefit from counsel, all counsel who are appointed must be competent as defined by the rules of court. So that's why you're all here today, because you're competent. So what does that mean in terms of the rules of court? You're in good standing with the state bar. You have training in juvenile dependency law. You have adequate forensic skills. That means you know how to cross-examine a witness and put on evidence. You have knowledge and comprehension of the statutes, the purposes and goals of dependency, specific statutes, rules and cases, and procedures for filing writ petitions. That one is part of your job as trial counsel, whether you like it or not. And so that's why you have to know those procedures. The rules of professional responsibility, professional conduct actually is what they're called in California. New rules adopted in November of 2018. This was in the old rules as well. But so basically, you know, you're failing to perform legal services with competences against the rules. And competence is defined to mean applying learning and skill and mental, emotional, and physical ability reasonably necessary for the performance. So in other words, you can't have a caseload so huge that you can't physically do the work necessary to do the work competently. It is the responsibility of each local court to enforce the competency requirements for appointed dependency counsel. And each local court is supposed to have a set of local rules as to what is expected of competent counsel, in addition to anything that might be in the rules of court. Some counties have and some counties haven't. I don't know whether Contra Costa has or not, but you should check your local rules if you haven't looked at them recently, and to see whether they say anything about expectations of the minors' counsel. There is also a requirement that each court have a local rule that says how people can complain about the competency of the minors' counsel. And this is another one it's important to look at, because depending on the county, who has the right to complain differs from county to county. In some counties, it's only the child and the parents. In some counties, it's the child, the parents, and their attorneys. In some counties, it's the child, the parents, the attorneys, the CASA. Some cases, it's not the parents, but it's the child and the CASA. So the foster parent, the caregiver, whatever, that's different from county to county. So you should check your local rules. You're supposed to have, to be competent, training and education, 8 hours before you get appointed and 8 hours every 3 years. Your training and education is supposed to cover dependency law, statutes, rules of court, cases, trial skills, writ procedures, and then this sort of multidisciplinary stuff that is not exactly the law, including child development, child abuse and neglect, substance abuse, domestic violence, family reunification and preservation, and reasonable efforts. So, what are the duties of the child's attorney? 317D says, counsel shall represent the child at the detention hearing and at all subsequent proceedings before the juvenile court, unless relieved by the court on substitution of other counsel or for cause. So basically, you're stuck with that kid till they turn 21, unless you somehow get out of the case before then, by either withdrawing or having other counsel substitute in, or you get kicked off because your client complains. You can do a Marsden motion, which is a thing that People versus Marsden is a procedure in criminal law where people can ask the court to appoint them a new lawyer because they either feel like their lawyer isn't doing a good job or their communications have broken down. It also applies in dependency cases, Marsden does. So your client can complain and ask the court to appoint you another lawyer. And depending on the client, you may be secretly hoping that the court grants the Marsden motion. Okay, so this is very important. 317E1 says that counsel is charged with the representation of the child's interests. It does not say best interests. Contrast with the probate code and the Family Code, both of which have provisions for appointing counsel for the minor in guardianship and family law matters. They specifically say the duties of the child's counsel are to represent the child's best interests. So the legislature knows how to say best interests when it means best interests, and it didn't say best interests, it said interests. If the child is a non-minor dependent, then counsel is charged with representing their wishes, except when their wishes conflicts with their protection or safety. I suggest to you that a non-minor dependent is an adult, and your job is, you don't decide what's in your client's best interests when you have an adult client and then represent something other than what your client wants under those circumstances. So in spite of the fact that 317 says it, I would be very, 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 very careful if I found myself in that situation. Okay. The code specifically says, 317E2, that you shall, mandatory language, make or cause to be made any further investigation necessary in good faith to ascertain the facts, including interviewing witnesses, and shall, mandatory language, examine and cross-examine witnesses. So you're supposed to be a lawyer. Counsel may introduce their own witnesses, may make recommendations to the court concerning the child's welfare, and to participate further to the degree necessary to adequately represent the child, not the child's best interests. Okay. Rule 5.660 has a list of things that in the standards of practice that basically says the child's attorney is expected to do the following: contact social workers and other professionals associated with the child's case. Sorry, I've got a scratchy voice because of allergies. Contact social workers. I don't know if you're in a county where the county council takes the position that you're not allowed to talk to social workers because they're represented. They're not, the county council represents the agency, not the social worker. But the rules of court say you have to contact the social worker. So you might want to point that out the next time the county council tells you you can't talk to the social worker. You're expected to work with other counsel and the court to resolve disputed aspects. In other words, if you can settle it without a contested hearing, then you're supposed to do that. But that doesn't mean you should settle everything, because it doesn't require you to settle everything. It only requires you to settle what you can settle, reasonably settle. And it requires you to adhere to the mandated timelines. So guess what that means? Jurisdiction hearings are supposed to be held within 15 days of detention. Dispo hearings are supposed to be held within 60 days. No more than 6 months, et cetera, et cetera. 352 is the statute that says continuances are bad. They're not supposed to be granted unless they're in the best interest of the child. And as counsel for the child, then it is part of your duty to basically argue in favor of not dragging the case out forever, arguing against continuances, because the child has the right to have their custody status determined as soon as possible. And, you know, the longer you drag it out, the worse it is for the child. Okay. 317, if the child is 4 or older, counsel shall interview the child, mandatory language, to determine the child's wishes and assess the child's well-being, and shall advise the court of the child's wishes. So it does require you to tell the court what the child wants, one way or the, even if you don't think it's your job to advocate for what the child wants, you still have an obligation to tell the child what the child wants. And how you determine that is you interview the child if the child is 4 or older. But under the rules of court, I think you have to interview the child even if the child is less than 4. We'll get to that in a minute. Okay, so Rule 1.4 of the Rules of Professional Conduct require you to inform the client of any decision or circumstance with respect to which disclosure or the client's informed consent is required by the rules or the State Bar Act, and to reasonably consult with the client about the means by which to accomplish the client's objectives. Means you got to talk to your client. You cannot represent a client that you do not communicate with. If you do, you're violating the rules of professional conduct if you don't communicate with them. Okay. You have to keep the client reasonably informed of significant developments, including promptly complying with reasonable requests for information. So if your client calls you or emails you, you're supposed to call them back or email them back, and provide them copies of significant documents when necessary to keep the client informed, and to advise them about anything about your conduct when the client is expecting you to do something that's not permitted by the rules of professional conduct or other law. So if your client wants you to, argue for an order that the social worker take them to Disneyland, you probably don't have to do that. Okay, rules of professional conduct explain the matter to the extent reasonably necessary to permit the client to make informed decisions. Again, you have to communicate with your client. You must have client contact. Reasonable or reasonably as used in the rules means conduct of a reasonably prudent and competent lawyer, not a reasonably prudent and competent dependency lawyer, but a reasonably and prudent lawyer, a reasonable, prudent, and competent lawyer. Okay, then we have the rules of court, which say that attorneys or their agents are expected to meet regularly with the child client, regardless of age or ability to communicate. Some places this has been interpreted to mean that if the attorney has an investigator or a social worker who visits the clients, and the attorney never has to have any contact with the client based on this rule. But the problem is the statute requires the attorney to interview a child who's 4 or older. Doesn't say anything about the attorney's agent. And the rule also says that the attorney, not the attorney's social worker and investigator, must have sufficient contact with the child to maintain an adequate and professional attorney-client relationship. Meaning, you gotta meet with the child often enough that the child knows who you are and that you're their attorney, what your job is, what's your relationship to them. So it's hard to have an adequate and professional attorney-client relationship with somebody you never laid eyes on. Okay, there are some limits on advocacy in Section 317, which creates interesting issues. The statute itself says that counsel may not advocate for return, i.e. to parental custody of the child, if to the best of counsel's knowledge. So it requires your personal knowledge. Return would conflict with the protection and safety of the child. So when you take a position adverse to the client, in a situation where the typical situation is the child wants to go home. Lots of kids, they want to go home, but it's not safe to go home because, the person who molested them is still living in the household and mom doesn't believe he did it, or whatever, you are not supposed to, you cannot advocate for the child's return under those circumstances. So what do? If you take a position adverse to what your client wants, the conflict of interest problem, and you may be revealing confidential attorney-client information in trying to explain why you're arguing for something against what your client wants, because you do have to tell the court your client's wishes. Some people think that the way to resolve this is to tell the court, this is what my client wants, but then you do not say anything. You do not advocate that the child should be returned. You just take no position on that, on whether or not they should be returned. It's just my client, this is what my client wants, this is what my client wants. Okay. The statute says you're not required to assume the responsibilities of a social worker, and you're not expected to provide non-legal services. That's kind of, difficult in this business, because there's so much going on that is non-legal that the child often needs advocacy about. So it's sometimes hard to draw the line. The rule defines non-legal services as services unrelated to the child's legal representation, whatever that means. But for it to be unrelated, in a dependency case, it would have to be something pretty far out there, I would think. Okay. The statute does specifically require that counsel for the appointed counsel has to investigate, mandatory language, any interest the child might have beyond the scope of the case. So there can examples, they might have a tort claim, particularly if they were molested in foster care, they might have a tort claim against the county, or they were in a traffic accident and there's a tort claim against the driver of the other car. There might be SSI, Social Security eligibility issues. There might be educational special ed disability advocacy that needs to be done, or the child may qualify or should qualify for special immigrant juvenile status. I've got that backwards. And somebody's got to, do the work to make that happen. Those are examples of other legal interests in forums outside of the dependency court that, as child's attorney, you would be expected to bring it to the attention of the juvenile court, and then under 317, the court is not supposed to say, how interesting. The court is actually supposed to appoint somebody, or you, to take to address whatever the other legal proceedings might be. There's a few cases having to do with tort claims that basically say the court cannot appoint you to be the kid's GAL for the purposes of their tort claim. The court can appoint someone else to investigate whether or not they have a tort claim, and perhaps identify and get counsel on board for the child in those cases, and maybe be the GAL for the purposes of the tort claim, but it's not you, not your job. Okay, so one of the duties of the child's counsel, I believe, is to protect their right to attend the hearing. They are parties to their own dependency cases. Under 349, they have the right to participate in their own dependency proceedings. There is no age limit. It doesn't say if you're 10 or older. It says children have the right to be present and participate. Now, obviously, babies probably don't care about coming to their court cases, but kids younger than 10 may care, and they have a right to be there if they want to be there. They also have the right to notice, the right to attend, the right to be represented by counsel at hearings of siblings who are also dependents. This doesn't happen as much as it should. If you have kids who have siblings in the system and they're not all on the same calendar track, which is to say that their cases are not being heard at the same time on the same day, then they have right to notice of their siblings' hearings, they have a right to attend their siblings' hearings, and they have a right to be represented by counsel at their siblings' hearings. So you should be looking out for that if you have a client that you know has siblings in the system. And then if they're 10 or older, it's not just they have a right to be present, but if they're not there, the court has to ask, why are they not here? Is it that they didn't get notice, or were they not given an opportunity to be there, even though they wanted to be there? And the court is supposed to continue the case to get the kid there unless the court finds it's not in their best interests. So I think it's really the duty of the child's attorney to determine if the kid wants to be present, before the hearing. Talk to your client, do you want to be present? And notify the social worker if the child wishes to attend, so that the social worker can make appropriate arrangements to get the child to the hearing. And if your 10 or older client isn't there, unless you've talked to them and know they do not want to be there, then you should be objecting to the hearing going forward without their presence. And the reason you need to talk to them is it's happens more than it should, where the child is 10 or older, but is not present at the hearing. And often someone like the social worker gets up and said, I decided it wouldn't be a good idea for the kid to come to this hearing, so I told him not to come. If they're 10 or older, it is not the social worker's decision. The social worker does not get to decide whether or not the child gets to come. If the child is 10 or older, it's the child's decision. Okay. It is your job to assert the privileges on behalf of your client. You are not obviously permitted to violate their attorney-client privilege. It's right in the rules. And then, of course, it's in the rules of professional conduct that you can't reveal confidential information unless you have the informed consent of the client. You may have a question sometimes about whether the client is capable of giving it informed consent. You should always ask the child before you say whether you can share something with the social worker or whomever before you do, but it's going to be case by case in terms of the age and competence of the child in question. So, attorney-client privilege, as far as the B&P code is, Business and Professions Code is concerned, is sacrosanct. Duties of the attorney to maintain inviolate the confidences of the client. A question that comes up every once in a while is, what is the situation if the attorney is employing a social worker, and a lot of children's law offices sort of employ social workers as part of their multidisciplinary team, and the social worker is working as the attorney's agent, but is a mandated reporter under the Child Abuse Neglect Reporting Act. I don't think there's anything definitive one way or the other. If I had to argue it, it would be my position that just because they have a social worker license doesn't mean they're doing social work when they're acting as the attorney's agent, and that therefore they do not have to report confidential communications. That also may reveal child abuse or neglect. The rules of professional conduct say you can't use that information to the disadvantage of the client unless the client gives informed consent. So that means your agent can't use the client's information to the client's disadvantage either. Okay. You also have a duty to protect all those other evidentiary privileges: psychotherapist, patient, physician, patient, and clergy, penitent. The lawyer for the child is the holder of the privilege. So it's your job to assert the privilege on behalf of the child, unless the child is sufficient age and maturity to make their own decision about the privileges. If they're 12 or older, they're presumed to be competent to assert or waive their own privileges. But otherwise, you have to still assert the privilege on their behalf, unless and until the child waives it, and then the court has to determine the child's competency to waive if the child is under 12. No, he's under 13, really, because it's a child over 12. All right. Avoiding conflicts of interest. This can get very hairy in dependency cases. Obviously, under the rules of professional conduct, you cannot represent a client if it's adverse to another client. You cannot represent a client if there's a significant risk that representing that client is going to be limited by your responsibilities or relationships with another client.
Jan, I have to interrupt you for just one second. We have a question from
Okay.
Ellie. It says, what should we do if the government social worker signs off on a release for the client's therapist's confidential information without the attorney's knowledge or consent?
You should call up the therapist and tell them the release is no good and that they cannot honor that release, is not legal, and the therapist should not give any information to the social worker, and determine whether the therapist has given information to the social worker under the phony release until you found out about it. But then I think you have to notify the social worker that the privilege, they don't have the authority to waive the child's privileges. They cannot give a release. It's not that uncommon in a lot of places where, particularly the therapist who's like, you know, an MFT trainee who's doing their hours under Medi-Cal, they don't really understand the extent of privileges. To literally remind both the social worker and the therapist as soon as you get on the case that the social worker, that the therapist may not share confidential information with the social worker, and the release from the social worker notwithstanding, and then it is inappropriate for the social worker to sign a release on behalf of the child, since the attorney is the holder of the privilege, not the social worker. Does that answer the question? Yes.
There's another comment. It says, the department never informed me and never provided a copy of the release and discovery. It was deliberately kept from me.
Well, then the answer is, if there's a bunch of stuff in the report, and I had this case once, in the report that came from the therapist in violation of the attorney-client privilege, confidential information, I think you go in and move to strike the report and ask the court to order the department to remove the entire report from the file and to file a new report that does not have any of the confidential information in it. So it's not something the court can rely. I mean, the court read it. It's in their brain. They read it. It might be in their brain. They read it, but you can still take it out of the record. And so it's not evidence that legally could be used to support whatever finding the social worker is asking the court to make based on that information.
Okay. Thank you. And also, we have a comment from Amanda. Question: if in FM, the parent holds privilege, correct?
No. As long as the child is represented by a court-appointed lawyer, even if it's FM, the parent and the child are considered not to necessarily have the same interests. They may have an interest in the whole family getting back together, but their legal interests still may not be the same. And so the answer is the lawyer is still the holder of the child's privileges. There's actually something which a lot of people are not aware of that's in the health, I want to say the civil code, that is basically says, that talks about therapists and who they can release information to and stuff. And it says that if the child is a dependent of the court, then the therapist is not supposed to release information to the parents.
So the parent can't sign the release of information.
They can sign it, but it's not valid to authorize the therapist to give information to the social worker or to the parent, as far as that goes, because the child is represented by an appointed lawyer and is still a dependent of the court.
Okay.
As long as there's an open case.
Thank you.
Yes. Anybody else? Okay. So avoiding conflicts of interest. Potential conflicts of interest that might come up and that you should look out for. You represented the parent at some previous point in perhaps even a different case, like a family law case or a guardianship, domestic violence proceeding, or in a prior dependency case. You represented the parent when they were a child in the dependency case, but now they're a parent. You still may have a conflict of interest. You still probably have a conflict of interest. And you should not be taking on representation of the child under those circumstances. There is an exception that the Supreme Court adopted in the Charlie C case, which basically says if you're a public law office, whatever that means, I think it means like the public defender or a nonprofit organization that basically it exists to provide court-appointed representation. In those circumstances, you could have two attorneys, or you could have two attorneys in the same organization representing clients who otherwise might have conflicts of interest. If they have the appropriate confidentiality separations involved so that one is not looking at the files of the other in the course of the dependency case. But the burden is on the law office to establish that there is no conflict. Question?
Yes, the question is, the older sibling keeps causing kids to get moved from caregivers, younger sibling along for the ride. At some point, conflict of interest for younger sibling, baby, to not keep getting moved, time for separate counsel?
Well, the answer to that is, the conflict of interest that they're really thinking of is somebody has told, is that the problem is one of the clients has told you something in confidence that you are going to use against another client. But if you have clients that you are representing who are siblings, the Judicial Council really doesn't want you to dump one sibling or the other because of the cost. And Rule 5.660, we'll talk about that a little more in a minute. But I think that when arguing for, let's say, okay, is your client getting kicked out and you're arguing for your client to move, or are you arguing for your client to stay? If you're arguing for your client to stay, the position you are taking does not hurt your other client, then not necessarily. And if your other client is a baby and hasn't given you any confidential information, then you probably don't have a conflict unless your older client has given you confidential information that could be used against your younger client. As far as the Judicial Council is concerned, Absent some confidential information you learn from one that you're using against the other, that is not a conflict of interest. I, on the other hand, would probably say, Your Honor, I think I have a conflict of interest, and I haven't received any confidential information for the baby, so please appoint separate counsel for the baby.
Okay, thank you.
And see what the court will do with it. I mean, that's I think it's a really tough call, because yeah, that baby's getting drug around from here to there because you got this older kid who's acting bad, and as we know, placement changes are bad for kids. So if one kid is having to move a lot because of a sibling thing, and you know what, sibling relationships don't trump all, just like relative placements don't trump all. You got to look at it case by case, and keeping the sibling relationship is not necessarily the best thing for every kid in the dependency system. And in that case, it might be better for the baby to not maintain the sibling relationship. So, but if your client, the older client, wants to maintain that relationship, then maybe you do have a conflict of interest around that.
That was very helpful. Thank you.
Okay. And then you have the whole child's wishes versus best interest thing, which is another potential conflict of interest, because you're basically saying my client wants this, but I, as the lawyer, think this is a very bad idea. As by way of example, I once had a lawyer call me up and tell me this. My hair stood on end as she's telling me this story. She says, well, at the dispo hearing, the kid really, really wanted to go home. So I argued, as a lawyer for the kid, I argued that the kid should go home. But then I put on my GAL hat and argued that the kid should not go home because it wasn't in his best interest. And now the kid wants to appeal. And as his GAL, do I have to sign the notice of appeal when I don't think it's in his best interest to appeal? I tried to explain that there are not two hats. There's only one hat. That's the lawyer hat. And we'll talk about a little bit more about that in a minute. But you don't have one role where your job is best interest and a different role where your job is representing what the child wants. You've only got one job, and that's representing the child. Okay. This is the rule I was talking about, where the judicial council doesn't want lots of lawyers for siblings. Attorney must decline to represent one or more siblings if at the beginning there's an actual conflict, and sometimes that's obvious, or circumstances specific to that case present a likelihood that there's going to be an actual conflict. For example, the allegations of the petition are that the older child beats up on the younger child and mom fails to protect. Pretty much conflict of interest among the two clients. You're going to either have the younger one testifying against the older one, or not, but that's potential, and that's probably a case where you shouldn't try to represent both. Okay. But they go on to say there is no automatic conflict of interest if they're of different ages, they have different parents, the conflict is theoretical or abstract. Some siblings are more likely than others to be adopted, and I really quibble with that. Or they have different permanent plans, and I really quibble with that as well. But those standing alone, as far as the judicial council is concerned, is not enough to declare a conflict of interest. But on the other hand, it does say that you, as the attorney for all the siblings, have an ongoing duty to evaluate the interest of each sibling and decide whether there's a conflict. So standing alone, no actual conflict if those things I mentioned above. Just because the siblings express conflicting desires or objectives does not necessarily create an actual conflict. if siblings give differing or contradictory accounts of events, but the things that they're not agreeing on are not material to the case, then you don't have a conflict of interest. So whether the older sibling beat up the younger sibling would be material, presumably if the petition was based on mom's failure to protect, for example. But if it's, you know, when somebody's birthday was or something like that, then it is not sufficient that you get to withdraw from the case as far as the judicial counsel is concerned. If you think there's an actual conflict, then you are required to basically do what you need to do to protect each child's interests and see that they are not prejudiced. And then you must notify the court of your conflict and ask to withdraw and have another lawyer appointed. We talked about this a little earlier. You can continue to represent some if you didn't receive any confidential information from the siblings you're no longer representing. And your continued representation of some siblings will not prejudice the other siblings. Sometimes when a conflict comes up in a case involving siblings, you got to withdraw from the whole case and ask the court to appoint entirely new counsel for all of the kids. Okay, so this is part of being in contact with your client. The law requires the attorney for the child to provide the attorney's contact information to the caregiver no more than 10 days after you're told where the care, you're given information by the department, presumably. You know, here's the caregiver, here's where they live, and here's their number. So in other words, you're supposed to give information to the caregiver as to how they can get in touch with you. You're also supposed to provide that information or how the child in their care can get in touch with you. If the child is 10 or older, then you must also provide that information to the child. The agency is required to provide you with new placement info within 1 business day of the decision to change the placement being made, and 10 days in advance of the placement change if the change will separate siblings. This is kind of interesting because there's now a 14-day notice requirement in addition to that. That's within 1 day of making the decision that we're gonna make a placement change, as opposed to the placement is gonna happen on June 3rd, and 14 days before that, they gotta send you notice that it's gonna happen on June 3rd. Okay. The rules of court say that counsel is not to maintain a maximum full-time caseload that is greater than that which would allow you to meet the competency requirements. And they put the burden on you to decide how many thousands of cases you can handle before you can't meet the competency requirements. So appointed counsel shall have a caseload and training that ensures adequate representation, whatever that means. And the statute requires the judicial council to adopt caseload standards. They never have. They did a study in 2002, and some of you who've been around long enough may remember this, where you had to keep track of your time for 2 weeks and report everything you did to the judicial council for 2 weeks. And they used that information to come up with this, with a report that said, for an attorney to do everything they should do on a case, they shouldn't have more than 77 cases. For them to just be barely competent, to not be incompetent, they shouldn't have more than 141 cases. And lots of people are falling all over themselves and laughing because, of course, most places appointed counsel has more than the 141 maximum that the Judicial Council's 2002 study decided was the most you should have. They did another caseload report in 2008, at which point they decided that if you had a half-time investigator, you could have 161 maximum cases. If you had a 3/4-time investigator, you could have 188 maximum cases. If you had a full-time investigator, you could have 228 maximum cases. There's this, you know, for the last 45 years, for as long as child welfare as a area of the law has been around, there has been this debate over whether the child's attorney's job is best interests or child's wishes, representing what the child wants. Pointed out already that the statute says child's interests, it doesn't say best interests. 317C says primary responsibility shall be to advocate for the protection, safety, and physical and emotional well-being of the child, which sounds a little bit like you get to decide what those things are, and that's what you should advocate for. But then you're limited to, and 317E, which is you can't advocate for return if it's, to your knowledge, not consistent with the protection and safety of the child, which also sounds like best interests, but it also has to do, specifically requires it to be based on your personal knowledge, not your general opinion about what or what is not is in the best interest of children. So the ABA adopted standards of representation in 1996. I've got the URLs in the program materials if you actually want to go look this stuff up. As far as the ABA is concerned, the child's attorney is supposed to provide legal services to the child and owes the same duties of loyalty, confidentiality, and competent representation as a lawyer owes to an adult client. And the child's attorney must represent the child's expressed preference and follow the child's direction throughout the course of the litigation. If the child is unable to express preference because of age or disability, then the attorney is required to make a good faith effort to determine what the child would want or wants, or to request the appointment of a separate guardian ad litem to argue best interests. Where the child doesn't have a preference, so I don't know, then you determine what the child's legal interests are, and that's what you're supposed to advocate for. What you do in the situation where what the child says they want would be seriously injurious, as opposed to being against what the lawyer thinks is in the child's best interest, then according to the ABA, you should request the appointment of a separate GAL, and you should continue to represent expressed preferences, unless the position the child wants you to take is either not allowed by law or is without factual foundation. In other words, there's no basis for making an argument for what the child wants. The NACC, National Association of Counsel for Children, was a little uncomfortable with that ABA standard, saying that child-directed representation does not necessarily require robotic allegiance to everything your client wants you to do. It involves, you're an attorney. Part of your job as an attorney is to counsel your client on the alternatives and the pros and cons and whatever of all of the potential outcomes. And that, you know, you should be sitting down and talking to your client when they say they want something which sounds like it's not a really good idea, before just going in and arguing whatever it is your client wants you to argue, if it doesn't make sense. At the end of the day, what you want is an outcome that serves the child with an outcome that you and the child agree on after you've talked about the available options. So again, the kid says, I want to go home, but the sexual predator boyfriend is still in the house, and or husband is still in the house. And you say, well, you know, I will tell the court that that is what you want, but you need to know that the judge is probably not going to go for that. So here are your other options if the judge doesn't agree to send you home to live with your mom. Do you want to live with your grandma? Do you want to stay in the foster home where you are? Do you want to live with your cousin? What do you want to do? So in other words, you got to talk to the kid. But again, you have to have a relationship with your client in order to carry out this model of representation. When, you know, according to the NACC, you can either substitute your judgment where you feel like what the client is asking for is based on, in effect, disability or client incompetence in the sense of too young to really make an appropriate decision. Or you can ask for the court to appoint a separate GAL to argue whatever the child's best interests are, and you continue to represent their wishes. If the child cannot cannot participate in deciding the position, either because they're too young or disabled in some way, then the attorney can substitute their judgment, but they're supposed to base it on objective criteria, not on your personal opinion. So that means you've got to investigate the child's circumstances, know what they are, what condition, what shape is the kid in at this point? Are they really, really upset? Are they withdrawn? Do they care? Do they not care? What are the options? And you always have to look at that sort of psychological parent, current caregiver versus family kind of thing, particularly when it's a placement change issue. And you need to go talk to experts. Talk to the pediatrician, talk to the therapist, talk to the teachers, talk to the social workers before you formulate an opinion on behalf of a client who is unable to formulate their own opinion. And it's possible for a kid to be incompetent about some things, incompetent about other things. And considering you're theoretically representing this kid for the next, until they turn 18 or 21, you know, at some point, they become competent simply by the virtue of their increasing age. So if you get to the seriously injurious part and talking to the counseling the client does not get them to change their mind, then you should request the appointment of a GAL. And you continue to represent their express preference unless not allowed by law or without factual foundation. And I've actually had that case. Number of years ago, I was appointed as the child's GAL in a case where the 14-year-old, what she wanted was to go live with her 37-year-old boyfriend. And that was not obviously something that the court was going to do. But the child's attorney felt like she had to basically, I think the child was maybe 16, but anyway, felt like she had to stand up for that. So I got appointed to be her GAL, which meant I got to argue separately from her attorney that it was really not a really good idea to send her to live with her 37-year-old boyfriend. Okay, so what does the case law say? The only Supreme Court case on the issue is Josiah Z. It says, it uses the words best interests, but it uses it in terms of the client's best interests, not limited to children. They say the attorney has the power to seek dismissal of an appeal based on the attorney's and the client's evaluation of the client's best interests. The client's best interests remain the lodestar for counsel. When client is a child, the rule is no different. So they did not use best interest in the terms of, in terms of paternalistic, some grown-up will decide what's better for you, and that's the position they will take. They used it in terms of, when the client is a child, the rule is still you have to determine with the client what their best interests are. What is the outcome that they want from this case? The quotes are right out of the opinion. Although an attorney must zealously advocate for her client, she cannot unilaterally appeal or bring a motion to dismiss. A motion to dismiss requires the authorization of the child, or if the child is incapable of giving authorization, the captive GAL must authorize it. This was an appeal where the appellate lawyer wanted to dismiss the appeal that was filed by the trial attorney because the appellate attorney personally didn't think the position that the trial attorney was taking was in the best interest of the child. And the Supreme Court said, no, 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 that is not correct. You basically do what the client wants you to do. You can't dismiss a case if you haven't got the client's authority to do it. That if and the kids in that case were like 2 and 4. So the Supreme Court said, yeah, we recognize that they're 2 and 4. So they can't personally authorize you to dismiss the case. So the captive GAL is the person who has to authorize it. And that's kind of a function of the whole captive GAL thing, which we'll talk more about in a minute. The Josiah Z court recognized that at some point children become capable of giving informed consent to key decisions affecting their circumstances. Where that point has been reached is a factual question, and the Supreme Court, cites the ABA standards that we talked about earlier. Given the ages of the children in that case, the court said if the captive GAL was refused to authorize dismissal, then counsel would have the option of either zealously arguing the case or seeking to withdraw. In other words, if you don't want to make the argument your client wants you to make, or that your client's captive GAL wants you to make if your client's too young, then you got to withdraw from the case. They also specifically recognized that it may be appropriate to appoint a separate captive GAL when there is a conflict between the attorney role and the GAL role. Zamer G was a Court of Appeal case, which says, oh yeah, the attorney's job is to represent the best interest of the child. It says so right there in Josiah Z, except it didn't say that in Josiah Z. Just because they said Josiah Z said that doesn't mean it did. They also relied on Julie W, which was a case where specifically the attorney felt that return to the parent was going to be detrimental to the child, inconsistent with the safety protection of the child. And so that was that limited situation where the attorney could not argue for what the client wanted. And then they relied on a bunch of older cases, like from the 30s and 40s. It's actually more like the 60s and 70s, but when kids were not parties to their own dependency cases. Kristen B is a case that also says attorney's job is to represent best interests, and then it cites Zamer, which of course cited Josiah incorrectly. So you got two cases who say it's best interest, but their reliance on Josiah for that proposition is just wrong. Okay, Some people think that because the attorney for the child is often also the child's captive GAL, that status somehow resolves the issue and means you're supposed to argue for best interests. The duties of a captive GAL, according to Rule 5.662, are to obtain a first-hand clear understanding of the situation and needs of the child, and to make recommendations concerning best interests of the child as appropriate under E and F. E, however, says of the rule, the specific duties and responsibilities of the child's attorney, who is also appointed as a captive GAL, are those set forth in 317E and Rule 5.660. So if you're the attorney and you're also the captive GAL, your duties are attorney duties. Says it right there in the rule. And Josiah, the Supreme Court case, noted that there's potential for conflict of interest between the two roles, and then it might be appropriate to appoint a separate captive GAL in some cases. Here are the things that I think argue in favor of direct representation in the statutes. Besides the fact that 317E does not say best interests. Your duties include investigating, interviewing witnesses, examining and cross-examining, introducing witnesses, participating, adequately representing the child. The only thing that sort of sounds best interesty is making recommendations concerning the welfare of the child. It's not your job as an attorney to make recommendations anyhow. It's your job to advocate for your client. So that is the one thing in 317E. The rest of it is all attorney jobs, right? Investigating, interviewing, cross-examining, etc. Those are all attorney duties. And then again, there's the thing about you're not expected to perform social work and you're not expected to provide non-legal services. The rules expect you to meet with your clients regardless of age or ability to communicate, contact social workers and other professionals, work with other counsel, adhere to mandated timelines, have sufficient contact to maintain an adequate and professional attorney-client relationship, and you are not expected to perform services unrelated to legal representation. GAL arguing for best interest is not legal representation. Okay, other things to consider: the child's a party. If parties are entitled to be represented by, who are entitled to be represented by counsel, are entitled to be represented by counsel who represent their position as a party. They have a right to be present. They have a right to be represented by counsel. They have a right to address the court and participate in the hearing. If they're 10 or older, they're expected to be present. They have a right to be served with pleadings and reports if they're 10 or older, and they have a right to make a statement to the court concerning their placement. They have a right to procedural due process. At the beginning of the case, at the first hearing, the rule says the court must inform the parents and the child of procedural due process rights at the first hearing. The right to a trial, the right to subpoena witnesses, the right. Now, we all know that as a matter of practice, most courts don't do that, but that doesn't mean that the kid doesn't have the right to good representation just because the courts don't follow the law. Children, this is very interesting. Children who are 12 and older have to be personally informed of the provisions of Section 388, and they have a right to file a 388 petition. There's actually a judicial counsel form that they're supposed to be given that tells them about their rights. Suggests to me that, you know, if the child is told specifically they have a right to file a 388 petition, their lawyer can't refuse to do it because they don't think it's in the best interest of the child. The case law on due process and dependency cases says it's the right to notice and the right to be heard. And how can a child be heard if no one's actually advocating their position to the court? They may also have substantive due process 14th Amendment liberty interests at stake. Marilyn H. points out that children, that's a Supreme Court case, has fundamental right to belong to a family unit, to be protected from abuse and neglect, and to have a placement that is permanent and stable. And Santosky versus Kramer, which some of you might remember from law school, observes that one of the reasons for hearings and procedural protections is that literally dependency proceedings can adversely affect the child's physical liberty. You're going to send this kid off to live with strangers in foster care, you're literally controlling their physical liberty. And that being the case, they should be entitled to representation as to whether or not that's appropriate or not. Okay, in 2011, the ABA adopted something called the Model Act governing the representation of children in abuse, neglect, and dependency cases. And this is like the model rules and other things. It's a here states, if you're looking at something to adopt in terms of how children should be represented, here's something for you to look at and perhaps copy. It basically requires appointment of a lawyer for every child, who is bound by the rules of professional conduct, including confidentiality and zealous advocacy, and has access to the child's confidential information regarding education, health, mental health, social services, linguistic, and other information relevant to the proceeding. And the duties include interviewing and counseling, preparing the case, negotiating, participating in hearings and settlements, meeting the child at least once per quarter, consulting with best interest advocate, i.e. the CASA, when appropriate and consistent with confidentiality in the child's legal interests, representing the child in all proceedings before the court, eliciting the child's wishes in a developmentally appropriate manner. And includes guidance on diminished capacity. In other words, what should you do if you think the child is not competent to make their own decisions? It allows states to use a rebuttable presumption to say all kids, like they did with the privilege stuff. Kids 12 and older are presumed to be competent to assert their own privilege. So states could choose to set an age limit of which the child's ability to direct the representation is presumed, and it's only if they're younger than that that the substituted judgment can be used when the child is incompetent to make their own decisions. The fact that a child disagrees with a lawyer or is insisting on a position that the lawyer doesn't think is a good idea is not diminished capacity for the purposes of the model rule. Diminished capacity is determined using objective criteria, and it can be incremental and issue specific. So some things they may not have capacity to decide, and others they do or will. Okay. Rules of professional conduct. Rule 1.2. They were the new rules effective in California on November 1st, 2018, says a lawyer shall abide by a client's decisions concerning the objectives of representation and shall reasonably consult with a client as to the means by which they are to be pursued. There was not a rule of professional responsibility similar to this before November 1 of 2018. And there is nothing in this rule that says, except if the child is a client. The lawyer shall abide by the client's decisions concerning the objectives of representation. So that's the biggest thing, in my opinion, that makes it pretty clear that if you're the child's attorney, your job is direct representation. Okay, so let's talk a little bit about what the duties of a child's attorney in the dependency case are. Issues that come up a lot for the child's attorney. So just by way of summary, you're expected to do an independent investigation. You're expected to communicate with your clients. I would point out that you can't represent either wishes or best wishes if you don't know your client. How do you know anything? You don't know your client, you can't do either of those things. You have to determine their wishes and legal interests. You counsel them about potential positions. When they're not able to formulate a position, you use objective criteria to come up with one. Avoid conflicts of interest between wishes and best interests. Ask for a GAL if there is one. Advocate for the child's interest in the courtroom. Take a position. I cannot tell you how many times I have read an appellate record where the attorney for the child, when asked what their position is, oh, I don't know, I'll wait till the trial's over to let you know. That's somebody who hasn't done anything, who has not done discovery, who has not done an investigation, who hasn't even read the file probably. It's your job to represent that kid. You've got to take a position on behalf of the kid. And you've got to put on evidence and cross-examine and whatever else you need to do to advocate for that position. Make appropriate objections, protect the record in case of an appeal. And if the child may have to testify, prepare them. And seek appropriate protections if necessary, like having them testify in chambers and so forth. Got to bring to the court's attention other legal interests that the child has that may need protection, like tort claims and things. And keep the court and the parties focused on the needs of the child. Sometimes the department and the parents get into sort of this, this adversarial thing back and forth between them, and somehow the child and what the child's needs and what the child's interests are totally get lost in the shuffle. So keep reminding people what this is about. Okay, so here are issues that are important for the child that I think as the child's attorney you should be doing. The first one's parentage. This is supposed to be done at detention. I cannot tell you how many counties they don't do a paternity inquiry at detention. And then 2 years from now, mom comes up with some guy that she says is dad, and then there's all kinds of drama around that. So as a child's attorney, you probably should be speaking up at the detention hearing and asking the court to do a paternity inquiry. Has the department done due diligence in locating? Have they attempted to serve alleged fathers? Did they serve them with a JV 505? They are required by 316.2 to serve anybody who's not presumed, basically, with a JV 505. There is also something called the JV 500, which is a judicial counsel form that the court is supposed to order the clerk to send to child support services to inquire whether there is a voluntary declaration of paternity or a judgment, a paternity judgment on file with the state. And they're supposed to respond within 30 days. So you sort of don't have these, oh, he signed a voluntary declaration of paternity people showing up 2 years into the case. Question.
Yes, can you please explain to the group the difference between the paternity inquiry and requesting information from CDSS? They get confused in Contra Costa.
Okay, well, first of all, 316.2, yes, they do. 316.2 and the rules of court say that they're supposed to be a literally questioning of whatever parents or family members who may be there as to if the parents aren't married to each other and the child is not everybody says the child is a product of that marriage, then there's a need to do a paternity inquiry. As we all know, in probably 90% of dependency cases, there is not an intact marriage with children who are children of the marriage. So the court is supposed to do an inquiry of the mother, of the father, if there's anybody there claiming to be the father, and it can get a little awkward because, one of the questions is, and who did you sleep with at the appropriate time? Which I've been in court when the answer was something that the guy who thought he was the father didn't know about. So, you know, but the court is supposed to specifically ask these questions. In counties, do the different depending on the county, but a lot of them, they literally put the parent, whoever's there, under oath, and either have the county counsel ask. There's a list of questions in the rule and a list of questions in the statute. Specifically, you shall ask these questions. So they have the county counsel literally voir dire the parent with all of those questions. That's the paternity inquiry. Sending the JV 500 to child support services, it's a totally separate deal. That's to find out if there's somebody mom didn't mention, for example, or that there's a paternity judgment against, or who signed a voluntary declaration of paternity, or they do the paternity inquiry and mom says, oh yeah, he signed the birth certificate, which gets interpreted to mean that there is a voluntary declaration of paternity, but nobody ever actually eyeballs the voluntary declaration of paternity. And so people are being found to be the presumed father based on some representation that he signed the birth certificate, when in fact he didn't ever file a voluntary declaration of paternity. The JV 500 will establish whether they did or they didn't sign a voluntary declaration of paternity. So, and it's mandatory. It's mandatory. It is supposed to happen every time there is any question about parentage. Most courts don't do it, as far as I can tell. But if you're representing the child, the person who gets, who is most adversely affected when some previously unidentified person pops out of the woodwork, 18 months, 2 years into the case, is the kid. So if you represent the child, who does the child talk to your client, assuming your client's old enough to discuss this. Who do they think their parents are, right? Mom's boyfriend has been around for the past 5 years, and the kid has been living with mom and mom's boyfriend. As far as the kid is concerned, mom's boyfriend is his dad. Hey, then maybe a 7611D finding is appropriate. But as a child's attorney, you need to know whether it is or it isn't. Public policy favors at least 2 parents. Now we can have 3 or 4. But so the other reason to do the paternity inquiry is, you want to scoop up all of the potential parents at the beginning of the case. A, because one or more of them might end up being an appropriate person to have custody of the child. And second of all, there might be 2 or 3 who might be people who can be there as supports for the child, even if they're not going to get custody. So, is there more questions? Okay. ICWA. This is another one where if they don't do it right at the detention hearing or whatever the first hearing in the case is, and there's a reversal 2.5 years later because of crummy ICWA notice, the person who is most adversely affected is the child. So as the child's attorney, it's your should be one of your responsibilities to make sure that ICWA gets done right. So first of all, you should be insisting that copies of all notices and documents filed with the court showing the mailing and the tribe responses and service on all counsel be served on all counsel, and you in particular. In the past, there was people, they would file stuff with the court and counsel would never see it. They would send notice to the tribe and counsel would never see it. The California version of the Indian Child Welfare Act was amended effective January 1, 2019 to require service on counsel of all of the documents. You need to get up and object early in office, often if the notice is not being done correctly. You should look at it. I've done a number of appeals where there were things like the notice that got sent to the tribe asks for maternal lineage and paternal lineage, and has questions like, what is the name of the child's grandmother? What is her address? Where was she born? Did she die? If so, when did she die? Where did she die? What's her birth date? Stuff like that. The kid is placed with the grandma, but the notice that the tribe sends, that the county sends to the tribe says unknown, 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 unknown. No, they could obviously, they know where to find grandma. Grandma presumably knows where and when she was born and so on and so forth. And if that information is not in the notice, that's automatic reversal 2 years ago, 2 years from now, to go back and do new ICWA notice. If the child, you also need to remember that if your child is an Indian child, there are benefits that may come from being enrolled on the tribe, in the tribe, depending on the tribe. So you should look into whether the kid should be enrolled. Depending on the tribe, they might be eligible for gaming money. If they're an Alaskan Native, the state of Alaska pays every Alaskan Native like a stipend every year out of oil money. There's college, well, there used to be college, I guess there still are, college scholarships all over the place for kids who identify as Native American. So there are fiscal advantages to being identified as an Indian child. And if the child really is potentially eligible for membership, you probably ought to look into that. We've talked about continuances. Continuances are bad. 352 basically says you're not supposed to grant them, court, if they're contrary to the interests of the child. But how can you determine whether they're contrary to the interests of the child if you've never met the child? And keep the timelines in mind, because you're also required by the rules of court to adhere to the timelines. So as a child's attorney, you should be objecting to continuances that will adversely affect timely resolution for your child client. So if they're dragging the baby's case out to the 18-month review, when the parents haven't done a darn thing or very little in terms of reunification, why? You shouldn't be doing that. The timelines say, you know, if it's a baby and the parents don't get their act together pretty darn quickly, then we move on. Okay, relative placement is very important. It's really important to kids when the child is placed with somebody they know and like. It's going to be a lot less traumatic than being placed in stranger foster care. So ask the child. The social worker is supposed to ask the child, but it doesn't hurt for you to ask also about relatives who the kid knows and likes, because those people's names might not be raised by the parents or anyone else, but the kid says, oh yeah, my auntie, you know, lives across town and I really like to go over to her house and she's nice to me. Then auntie's name ought to be given to the social worker as a potential placement. There is 309 has been on the books for, I don't know, 10 years, give or take, requiring the agency to basically search for relatives within the first 30 days of the case. And that by disposition, they are supposed to be in a position to recommend whether or not, you know, there is a relative available for placement. And a lot of agencies don't do it. There is a provision in 358.1 that's been there for a couple of years now that allows the court to hold what's called a due diligence hearing within 30 days to determine whether the social worker has used due diligence to locate relatives. And if you have concerns that nothing's really being done to look for relatives, you could ask for a due diligence hearing. You will not be popular. And, you know, the social worker will be mad at you, the court will be mad at you. But, you know, if people aren't mad at you, you're not doing your job. you ask the court to make the relative placement decision when there's a conflict. Social welfare agencies think that it's the social worker's decision to make the relative placement decision. And when there's no issues, then they can make it. But 361.3 makes it very, very clear that when there's a question, it's a question that has to be decided by the court at dispo. Okay. Let's look at visits. What does the visitation schedule look like? Is it working for the child? Little kids need more frequent visits to develop or maintain an emotional connection than big kids. I mean, teenagers, if they never see their parents, they, yeah, who cares? But little kids, there's that whole bonding and attachment thing. And if the visitation is once a week for an hour, that's not sufficient. Babies can't remember somebody that they saw for an hour last week, when the next week they only see them for an hour. So you've got to argue for a visitation schedule that A, meets the needs of the child. In this case, there's not going to be reunification. The chances for reunification are much worse if the baby never develops a relationship with the parent. So you got to push for that. If visitation is, if the department is arguing that visitation would be detrimental and they're recommending no visitation, but they're still recommending reunification, then you need to be saying, whoa, 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 whoa. If the visitation is detrimental and they can't visit, they can't reunify. So why are you not recommending a bypass? If there's no bypass reason, then there's got to be some kind of visitation where the child is protected. Supervised visits, visits only in the context of family therapy, whatever. But there's got to be visitation, or there's not going to be reunification, and the parents are going to have a really good lack of reasonable services argument when at the end of the day. Depending on what county you're in, sibling placement, sibling contact is either super important or not important at all. So, the issue should be for you, if they're a sibling, should they be together? What is their relationship? How important are they to each other? What efforts are being made to place them together? The department is supposed to make efforts to place them together. If they're not placed together, what kind of contact are they having, and how much contact should they be having? What does your client need? Is the contact appropriate? They're gonna have sibling contact, once a month or something. Is that really enough for your client? Maybe not. Is it happening at all? It's not unusual in cases where all of a sudden the sibling contact just falls off. And sibling contact needs to continue after permanency plans are made. So unless everybody's being adopted together, might be needing to look into post-adoption contact agreements, which the child's attorney is supposed to negotiate on behalf of the child. Or if they're all in, different foster homes or different relative placements or whatever, they're still supposed to be having contact. So it's your job as the child's attorney to make sure that's happening. Concurrent planning. You need to look as the child's attorney at whether there is concurrent planning. Is there a concurrent plan? It is supposed to be in the disposition report. When I was doing appellate work, I saw a lot of disposition reports that said something along the line of, the concurrent plan is if the parents don't reunify, we're going to start looking for an adoptive home. No, that is not a concurrent plan. Concurrent means going on at the same time. So the real issue is the place where the child is placed right now at the beginning of the case, a placement that can provide permanency and can meet the child's need on a long-term basis if the parents don't or can't reunify. This information is required to be in the disposition report and often is not. And you need to know something about the placement because you need to sort of assess whether the placement is one that you think would be an appropriate permanent placement. If the child is placed with the 95-year-old grandma, maybe not. Because you need to remember that if the child has been in a placement for 6 months, that caregiver can turn into a prospective adoptive parent. And the department's authority to remove that child from that home is limited by 36626N. So it's important to make that assessment because you don't want someplace that you think is wildly appropriate as a long-term placement turning into one by default just because the kid's been there 6 months. And if you don't, remember anything else that I said today, multiple placement changes are bad for kids. So try to keep the placement changes to a minimum. Object to completely unnecessary, wildly inappropriate placement changes. Okay. What's the service plan? So you got the DISPO report and it's got something attached to it, which is supposedly the service plan or the reunification plan or the case plan or whatever they call it in your county. So does it adequately address the problems that brought the child into the system? Why is this kid in the system? What were the jurisdictional findings sustained by the court? And, did they involve substance abuse or mental illness or domestic violence or whatever? And if so, what is in the plan to address those problems? Are there appropriate services for the child in the case plan? Like, is the kid going to get some therapy? I mean, I think every kid should, in the system by definition, kind of needs therapy, but often there's nothing in the case plan for the child at all. Or there are inappropriate requirements. There'll be a section of the case plan that says the child shall do this, go to school and not skip school without, blah, blah, blah. Read that stuff before you get to the DISPO hearing because sometimes they've just done a cut and paste job and, the requirements for the child are not appropriate. I had a case many years ago where the case plan said that the child was to refrain from consuming alcohol. The child was 2. So did that mean, no Tylenol for the kid if the kid was sick? Guess not. Okay. And then you got to sort of monitor what's going on with the child in terms of the services that they're supposed to be getting. Are there delays in getting the kid into therapy? Are there delays in getting the kid and the parent into conjoint therapy? Are there problems with visitation? You have to stay on top of that a little bit because probably no one else except possibly the caregiver or the CASA is going to tell you if there are problems. The social worker is unlikely to call you up and say, I haven't been doing my job. Okay. Is the placement appropriate and able to meet the needs of the child? This placement is probably the most, from the child's perspective, where they end up getting placed is probably the most important thing. So is it an appropriate placement? So, where do they want to be placed? Do they have a relative? Do they have a friend whose mother would be willing to take them in? Is their coach, willing to become a placement? Whatever. Talk to the child. We mentioned the whole after 6 months thing for PAPS. And placement considerations require you to actually have some knowledge of the placement. That means you've got to visit that kid in the placement at least once. Regularly is better. How do you know whether it's a consistent with the child's safety, protection, safety, well-being, etc. If you've never been there and you don't know what it's like. If the place is a pit with padlocks on the cupboards and you've never been there, you know, that's not a good thing when that comes out and you've never objected to that placement. And obviously, you know, you should be asking for a placement change if the placement is not appropriate, but the sooner the better. Okay. Findings. You need to make sure that the findings that are required for that hearing are being made. Why? Because occasionally there are reversals based on inadvertent failures of trial courts to make required findings, or making findings that are not the right findings for that hearing. Again, because of the tendency to cut and paste. Sometimes if you're in a county where the social worker's report recommends to the court what findings it should make, look at those findings and make sure that they're correct and that there is evidence to support them. I have seen cases where the proposed findings for the dispo hearing were review hearing findings, not dispo hearing findings. Well, if that case goes up on appeal, it's going to be a problem, and the person who usually ends up being adversely affected by a reversal on appeal is the child. So is the important findings, are they there? Is there a detriment finding if it's anything, if it's dispo or review hearing? So reasonable services finding at pretty much every hearing. And then there are what are sometimes called the Title IV-E findings, or routine findings that the court makes, which are the, you know, the placement is necessary and proper, and the department has done a blah, blah, blah job of looking for, you know, implementing the case plan. And they make those findings whether or not there's any evidence to support them or not. But you need to look at those, because every once in a while it might be appropriate to not let the court make those routine findings if there's really no evidence to support them, particularly the finding that the placement is necessary and appropriate. Doing appellate work, I have seen appellate decisions where there was some appellate issue about placement, and then the Court of Appeal says, oh, but the trial court found that the placement was necessary and appropriate, so, you know, it must be fine. And you can't complain about it because you didn't object to that finding. And you being the parent or the child or whoever. So look at those and make sure that they're not somehow going to be used against your client later, particularly if you don't think the placement is necessary and appropriate, then you need to say so. Okay. Yeah. Group home. Now it's supposed to call them short-term residential treatment programs, but they're still group homes. The statute now says that no child is supposed to be in a group home placement for more than a year, but that's kind of advisory. It doesn't say shall not, it just says shouldn't be. But still, it's something that you should be looking at and raising if your client is, you know, pretty much most teenagers are in some kind of a group home. If your client has been in a group home for more than a year. 361.2 says if the kid's age 6 to 12, their placement in a group home should not be more than 6 months. If an additional 6 months is recommended, then the agency director or the deputy director has to approve that. If the child's under 6, then it's a 120-day limit in the group home, and it usually is supposed to be only for assessment purposes. Oh no, it's 60 days for assessment purposes. And the reason it has to be approved by the agency director or deputy director is because with the federal law changes a couple of years ago, the feds are not paying for group home placements anymore after a certain amount of time. So if the recommendation is to leave that kid in a group home longer than the limits, the reason that it has to be approved by the director or the deputy is because it's going to be, the county is going to be paying for it, and there's not going to be any federal money. So they want to make sure that the people at the top of the totem pole know what they're going to be spending their money on. You can put a kid 6 to 12 in a group home if it's needed for evaluation. But if you're going to leave them there beyond 60 days, and this of course assumes incorrectly that your dispo hearing will be held within 60 days, you have to have a case plan that shows the reason, the need to continue that kid in that group home beyond 60 days. So if you represent a kid in a group home, you need to be aware that they need to be getting them out of there as quickly as possible. Okay. The ICPC, pain in the butt, particularly when there's appropriate relatives who live out of state who might be willing to be a placement for the child if the parents cannot be reunified. The regular ICPC process is way, way, way too slow. It takes too long, and then it creates problems for the child because the child's been in some other placement for the last year and a half when the ICPC on the relatives in Idaho finally gets passed or approved. And the relatives in Idaho, by the way, are, you know, complete strangers to the child. And it's different if they're not complete strangers, but it shouldn't take 18 months to approve the ICPC. There is such a thing as an expedited ICPC. It got passed into federal law about 5 years ago now. So you can ask for the court to expedite the placement if the proposed placement is a step-parent, relative, or guardian, and the dependency is due to the unexpected incarceration, incapacitation, or death of a parent or guardian. In other words, boom, the parent is gone. The child is 4 or younger, or part of a sibling group who has a child 4 or younger, or the child or the sibling has a substantial relationship with the proposed placement. So in other words, it's a grandma they go visit every summer. It's somebody they know already. Or the child is in an emergency placement. And I suggest to you that pretty much, you know, every kid is in an emergency placement. I think they mean in a placement that is not necessarily going to be permanent, is what the federal law anticipates. If it's any of those things, you can go get an order, it's a JV form, from the court asking for expedited ICPC, which then requires the county to email it to the state instead of putting it in an envelope and putting a stamp on it. And it requires the state to send it to the other state by email instead of putting it in an envelope and putting a stamp on it. And it requires the other state to basically act on it within 20 business days, which is, you know, ends up being about a month. And if they haven't decided in a month, then it gives your court authority to basically call a court in the other state and whatever jurisdiction is supposed to be doing that ICPC and asking for that court's assistance in getting the agency to do it quickly. And, you know, some people say, well, yeah, but California courts can't order departments in other states to do anything. But what do you think happens when a California judge calls a judge in Florida and says, hey, judge, can you help me out? We sent an expedited ICPC to your department and we haven't gotten to 30 days have passed and we haven't gotten a response. Can you help us out? What do you think happens when the local judge calls the head of the agency in that county and says, I got a complaint from California that you haven't, you know, acted on the ICPC? It's likely it's going to go to the top of the stack and it'll get acted on sooner rather than later. So our question.
Yes. Does the 4 or younger, or in a sibling group with one who is 4 or younger, assume the siblings are placed together and will remain so?
Yes, it does. It assumes that, in other words, the sibling group can have kids older than 4, but if you got one 4-year-old in the group, you can do an expedited ICPC for the whole group.
Okay, thank you.
Okay? Anything else? No. Okay. All right. Placement changes. Placement changes are bad for kids. So the first thing you need to know when you get wind of a placement change, you need to ask is, has the social worker developed and attempted to implement a placement preservation plan? This is 16010.7, which is new as of the beginning of 2019. A lot of counties still haven't gotten the memo. The statute assumes that there isn't a court order for or authorizing a placement change, and that the child is not at imminent risk of harm in whatever the current placement is. It requires the social worker, before making the placement change, to attempt to preserve the placement. And they're supposed to develop and implement a plan. The statute requires the caregiver to be involved in the development of the plan. It requires the department to consult with this child and family team. So you should be asking these questions. Did these things happen? Then, if after all of that, the plan doesn't work, they can't, nobody, the caregiver says, get this kid out of here, I can't keep him, or whatever, then the social worker has to give 14 days advance notice of the move to the parents, the caregiver, the child's attorney, and the child who is 10 or older. There's a provision in 16010.7 that says, unless everybody is in agreement, they cannot make unanticipated placement changes between 9 p.m. and 7 a.m. So it specifies that for the purpose of who has to agree to a move after 9 or before 7, the child's attorney is the child's representative for the purposes of agreeing to that. And, you know, if you're the child's attorney, and you can think of some reason why moving between 9 and 7 is appropriate, I guess you can agree, but otherwise I wouldn't be. But you have to be consulted. Okay. If they're placing the kid out of county, there's also a 14 days advance written notice requirement to the parents, the caregiver, the child's attorney, the child, CASA, tribe, and Indian custodian. The only time that's not required is if the child and family team basically agree that this placement is in the child's best interest and that no one who is entitled to notice objects to it. So if everybody agrees that moving the kid to live with grandma in San Joaquin County is the right thing to do, then the 14 days moving the kid out of county notice requirement does not apply, but otherwise it does. And once you have gotten notice, there's a JV form 556 that you can file within 7 days to object to the placement out of county. And if you do, then the department is not supposed to move the child until the court can decide the issue. You may have to bring this to the attention of the department, because a lot of them are completely unaware of this provision, and it's been on the books 20-25 years. Okay. Educational stability is another important issue if you represent the child. It's important to the child's well-being. So the child has a right to attend their school of origin, i.e. the school that they were going to before they got brought into the system. There is supposed to be notice to the court, to the attorney, to the educational representative within 24 hours of a decision to make a placement change that would result in removing the kid from the school of origin. So they have to tell you the minute they decide that they're going to place the kid somewhere else. Whether or not this doesn't eliminate the 14-day requirement, by the way. It just says, you know, they can't make the decision and then fool around for 3 weeks before they decide to give you 14 days notice. The rules say that the attorney must discuss the placement change, proposed placement change with the child and with the educational representative, and can ask for a hearing within 2 days. And again, there's a JV form for that if the move is disputed. So, you know, you need to keep careful track of when they give you notice, which probably won't have been within 24 hours of the determination, and make sure that you're filing your objection within 2 days of the date of the notice if you are disputing the move. If a hearing is requested, then again, the kid has to stay in that school pending a hearing. Until the court can hear it, the kid does not get moved from the school. The social worker has to write a report that is filed 2 days after you file your objection. And then the court has to determine whether the placement meets the requirements of the Ed Code and whether it's in the best interest of the child. Okay. If it's going to result in a change of schools, there has to be a CFT. Has to be a CFT. And the child's educational representative, if it's not the parent, has to be invited to the CFT. The CFT has to talk about whether staying in or returning to the child's school of origin is in their best interests, and whether they should whether the placement change that would result in the change of school of origin. And if the educational representative says the remaining in the school of origin or returning to the school of origin is in the child's best interests, then the CFT has to come up with a transportation plan for the child to attend their school of origin and extracurricular activities if the school is not placed, you know, in the district or near their original school of origin. Psychotropic meds. I assume for those of you who represent kids that you get a lot of these. I hope you're getting a lot of these, or maybe they don't prescribe psychotropics for kids in your county. If you get one, you should read the application immediately. These are filled out often by the social worker, and then there's a section that's filled out by a doctor, but sometimes it's a bit hard to read. You should, the minute you get it, or very soon thereafter, talk, because you've only got 2 days to make objections. You need to talk to your client, and if possible, the doctor, if it's a new medication. Does it have side effects? What are those side effects? Why are you prescribing this now, etc. If you are really not sure that, you know, this is either safe or the right thing for your client, or your client says, I am sick of taking all these meds and I don't want to take any more. I'm already taking 5 psychotropics. I don't want to take a 6th one. Then you should object, file the appropriate objections, and there's judicial counsel forms for all of this stuff. And once your client starts a new medication, you might want to check with them a few weeks later and say, how's it going? Because, you know, particularly when they're in a group home, nobody kind of listens when the teenager says, geez, this is really making me feel weird and I'm lethargic and I can't seem to get out of bed in the morning or whatever. And they just get blown off. And no one really pays any attention to whether or not that kid is suffering, if you will, as a result of the medication. Okay. We're almost there, guys. All right, so privileges, we really pretty much talk about this. You have to assert them unless the client waives. The client can waive if they're sufficient age and maturity, 12 and older is presumed capable. But you are the holder, not the social worker, not the parent. You are the holder of the privilege. But you should clarify with the therapist and the social worker if you need to, that the social worker is not the holder of the privilege. And any release signed by the social worker does not authorize the therapist to tell the social worker anything. Okay. Starting January 1 of this year, there is a new foster care Bill of Rights, and you need to know about it because it converted what was previously considered legislative policy into rights. The statute now says these are rights. And there are many new rights that were not in the previous version of the statute. So you need to be aware of and be prepared to go to court if you have to, if your client's rights are being violated. And keep in mind that arguing that something violates your client's rights may be, help support your advocacy on behalf of the child when, there's something going on that your client doesn't agree with. And, almost by definition, I think if it violates their rights, it couldn't possibly be in their best interests. I would certainly think about that as a potential argument. Another thing that you need to look at is likelihood of adoption. The purpose of termination is not to punish bad parents. It's appropriate only if adoption is possible, probable. So you need to look at, was it an assessment by an adoption worker as opposed to just the child welfare worker who doesn't have any adoption experience? Does the report discuss all the required elements? I think there's a case last year where there was a real problem because the report did not discuss all the required elements and it was found to have violated the child's due process. So as a child's attorney, you should object if the report does not cover all of the things that it's required to cover. And if there is any doubt that that child will be adopted soon after parental rights are terminated, you don't have somebody lined up in the wings, then you should ask for the 180-day continuance under 366-26C3, because that way your client doesn't become a legal orphan and never get adopted if in fact it turns out that they were a little over-optimistic about their ability to find an adoptive home for this kid, went ahead and terminated parental rights, and then no home materialized. Doing the 880-day continuance is much preferable to the legal orphanage. Okay, so we've talked about this, but if your client ends up a legal orphan, or the agency has decided to change the plan to long-term foster care, which I submit to you the agency does not have authority to do, then is there someone that this kid could, have a relationship with or act as parent or caregiver? If that termination is set aside, what does the kid want? And it's the child who files the 388 petition. So you as the child's attorney should be filing the 388 petition if the kid has not been adopted in 3 years or the agency effectively concedes that the child's not likely to be adopted. If the child's in long-term foster care, they're supposed to be continuously attempting to make a more permanent plan. It's supposed to be in the 366.3 report, and return to the parent is always supposed to be considered as a possibility if the kid is in long-term foster care. So ask the kid who important adults are. Is there somebody who might be willing to serve as a guardian? Is there someone who's willing to take this kid on in a more permanent arrangement? Ask the child. They might have some ideas. SIJS, if the kid's undocumented, you really need to do whatever needs to be done to make the kid, get the kid SIJS status. And you may need to make findings and orders propose findings and orders to do that. And if it's not something you can do in your court, then ask the court to appoint counsel to do it. Question?
I have a case like this, but I rep the parent. This is going back to the 388 issue with legal orphanage.
Yeah.
So I have a case like this, but I rep the parent, and child's counsel hates my parent. Can I force child's counsel to file the motion?
The answer to that is if the child is 12 or older, I suggest to you that the child can file their own damn motion, whether their lawyer wants to or not, because of that provision I talked about earlier, where the court has to inform the child 12 or older of their right to file a 388. But no, you can't force the parents, you can't force the child's attorney to file the 388 absent some showing that the child wants the 388 to be filed. In other words, the child is going to get those people back as his parents. If he wants them back as his parents, then they should file the 388. But if it's like, no way, then maybe not, unless there are relatives or other people related to the parents who could provide appropriate, stability for the child, whether or not he wants to reunify with the parents.
Okay, thank you. And also, Jan, just as a reminder to you, it is actually 5:11 right now.
Okay, well, the answer is we're almost done and we didn't start right at 3. So off we go. Just make sure that when your kid's about to age out, they've gotten all the services they're supposed to get. Are they going to ILSP? Are they doing, is the department doing all the stuff required by 391? And if they're, when the kid turns 18, make sure they know of their right to stay into the system and that they should come back and talk to you. If there's going to be a dismissal hearing, make sure the non-minor is there. Make sure they understand that JV form that says they got all that stuff when they sign it, which often they didn't get all that stuff and they don't know what they're signing. And remember that the kid cannot be required to remain independent if he does not wish to once he's an adult. And finally, writs and appeals, if there's an appeal by the parent, think about whether or not the child should have representation on appeal. If it's an issue that affects the child directly, like placement, parentage, sibling, contact, so forth, think about asking the Court of Appeal to appoint a counsel for the child, even though the child is not an appellant. Remember that if there's a post-termination placement for adoption issue, it is not an appeal, it's a writ, and you got to file it if your client has a problem with the decision of the court. And if other people have brought writs under 36626L, you might want to file a brief on behalf of the child in those proceedings. You can do a letter brief. So, and it's your duty to protect their interests on appeal. So adverse rulings against what your client wants, appeal it. Somebody else appeals, think about cross appealing. If you cross appeal, the kid gets a lawyer automatically. And make sure you ask for appellate counsel for your client otherwise, and cooperate with appellate counsel. And we're done. Thank you all very much. And you have my contact info if you have questions. So feel free to email me. Okay.
Thank you. And we have a comment. This program has been excellent. It gives us a lot to think about. Thank you so much for the gift of your time, Ms. Sherwood.
Oh, that's very sweet. Thank you. Thank you for saying so. Whoever said that.
That was Ms. Ramirez.
Oh, good. As opposed to my daughter. Great. Okay. Thank you. All right. We're done, I think.
Yes, I don't see any other questions.
Okay, good. Well, it is now 5:13, so we went over by about 6 minutes. I apologize to you all for going over it. Good luck.
Thank you, everyone.
Okay, thank you.
Thank you.
Are we done?
Yep, I'm gonna turn off the recording.